Welcome to Thursfield's Talk Legal, a vidcast series from one of the leading law firms in the Midlands. I'm Steve Dyson, a journalist who's talking to a range of solicitors at Thursfield's on legal topics of wide interest to the public or businesses. Today's episode is called Back to the Future, a return to the workplace. And joining me online to discuss this is Helena Morrissey. She's a Director of Employment and HR Law here at Thursfield's. Hello to you, Helena.
Hi, Steve. Thanks very much for having me today.
No problems, Helena. We're here to talk about the potential return to the workplace after the COVID-19 lockdown. And I was quite interested in your title for the subject, Helena, Back to the Future. I mean, while we're seeing more people returning to offices, it's not everyone, it's not all the time, and it involves all sorts of different elements, doesn't it?
Absolutely, yeah. I sort of entitled this "Back to the Future," and apologies for those that were hoping I was going to talk about the the '80s film. No, it's because we are going back to the workplace and we are going into the future. But the future is, although it's returning to the workplace, it's different. It's going to be different. I think that whatever normal is, it's going to be changed from pre-pandemic normal. Certainly for the short to mid term. And I think we're going to see a mixture of work styles now going forward. I've heard that some businesses have ditched the office-based model altogether and are asking staff to work remotely full-time. Others, in fact, are insisting on a return to the workplace on a full-time basis. But I think the majority of businesses will be looking to introduce a sort of hybrid model where some people will work part-time in the office and part-time at home, which I think is actually a positive thing to come out of COVID, because it does enable a better work-life balance for people. And I'd hate to see this return to the presenteeism that we had rife in workplace culture prior to the pandemic. And of course, it's not lost on me that many people have worked stoically throughout the lockdown in retail, in care homes, in the NHS, and that's absolutely marvellous. But certainly for those of us that are more office based, there will certainly be a change, I think, in the way that we work and approach work and the workplace going forward.
What are the legal implications of this, both for employees and employers?
Yeah, it's an interesting one, this, because people have been working at home over the past sort of 15 months or so, quite successfully in many cases. But of course, once the government's lifted its guidance that people should work at home where it's possible to do so, um, I think that employers will be faced with a lot of requests to continue working at home, whether that's on a full or part-time basis. And as a matter of law, such a request is technically a flexible working request because it is likely that people's contracts will say that their normal place of work is the office. So a request to vary that does carry with it some legal implications. Certainly, people shouldn't let employees continue working from home by default and just let that become the status quo without setting out certain parameters. I think the key here is if you're going to allow people to continue working at home, whether full or part-time, you do need to be setting out in writing the fact that you are going to allow this, but also the fact that there may be some stipulations, such as you will be required to come into the office as required for team meetings and other reasons. The fact that the employer might want to reserve the right to unravel the arrangement and require the employee to come back to work in the office at some point in the future if that's more appropriate. And these things won't be implied in any arrangement that is unwritten. So if you want to have these rights as an employer, you need to have them written now. And obviously, if somebody makes it clear that it is a formal flexible working request, you do need to comply with the prescribed timescales, deal with it within 3 months. And I mean, an interesting point will be, how do you decline such a request if you've been working successfully, if your employee's been working successfully at home for the last 15 months? How do you then say, no, I want you to come back to the office? And that's going to be a challenge. There are various reasons set out under the flexible working regime that employers can use. where it's going to have a disproportionate impact on customer service or on colleagues. There's various reasons that can be used, but employers do need to think carefully about how they're going to decline requests where, frankly, it has worked perfectly well uh, up till now. And also, employers also need to be a little bit careful, although they can rely on one of the government prescribed reasons, that you need to be a little bit alive to indirect discrimination. So if you've got a policy that you insist on individuals being in the office 9 till 5, and that could have a disproportionate impact, for example, on women with childcare responsibilities, and that could technically be indirect discrimination if you can't justify why you insist on that working model, i.e., an office-based model. So there are a few legal pitfalls here that will emerge once we do come out of this final stage of lockdown.
Of course, I understand. What about people, Helena, who are genuinely worried about returning to work because of health concerns over COVID and infections, etc.?
Well, absolutely, and there are concerns. I've been speaking to people both in my personal life and my professional life. People are concerned. If people have been on furlough for 15 months, or working at home, going back to the office can be quite a daunting experience. And indeed, I have heard that some individuals are being sort of egged on, possibly by unions, I suspect, to say that if they don't feel that the workplace is safe, they're entitled to stay at home on full pay. Now, actually, that's not as black and white as it sounds. As an employer, if you take reasonable steps to make the workplace as safe as you possibly can. So put in measures such as distancing, perhaps physical barriers, obviously hand sanitizers, you have thermometers to take people's temperature, and perhaps ask people to take lateral flow tests. If you've made the work environment as safe as you can, and you communicate that to individuals, then it is harder for them to say that they have a reasonable belief that they're in sort of imminent and serious danger. Which
Sure,
means that
sure.
any legal argument that they're entitled to stay at home falls away. And actually, the law requires employees to take some level of responsibility for their own personal safety at work as well. So if the employer has put in measures to keep employees safe, employees need to comply with those measures. But yes, I can see that people would certainly be worried. And it may not just be their office, they might be worried about their commute rather than the office. It's a difficult time, and the question is, what do you do if your employee fails, absolutely refuses to come back, whether it's the commute or the office environment that they're worried about, and ultimately an employer could dismiss. But I say that with caution. That would have to be the absolute last resort, and certainly. If anyone is in that position, I would recommend that they do speak to a solicitor or an HR advisor before taking that step. But ultimately, it could be the outcome.
That all makes sense, Helena. In terms of making the workplace safe, can employers insist on mandatory vaccinations before allowing people to return?
Yeah, this is a hot topic, isn't it, at the moment? I think the short point is, in terms of insisting on vaccines, no, probably not. I think there may be some rare sectors, rare examples where you can. So I know that in the press they were talking about medics, in the NHS and in the care home environment. But I think if unless you've got a very good reason to dismiss somebody for refusing a vaccine, I think would potentially be an unfair and possibly discriminatory dismissal.
Hmm.
But there are lesser measures that I think employers could implement, such as insisting on twice weekly lateral flow testing. Now, I'll be the first to admit doing a lateral flow test is not pleasant, sticking something up your nose and down your throat. But I think that at least enables people to keep a check on their own COVID status and to keep the workplace as safe as safer than it would be if people weren't regularly checking their COVID status. And although, yes, there is a certain element of personal infringement, I think that the greater good in terms of policy would effectively outweigh any personal inconvenience. And although we don't have any case law on this, because obviously none of these cases have gone through the system, which has got a huge backlog, my feel is that insistence with good reason and with justification on lateral flow testing would potentially be reasonable. And if somebody refused to do it, then they could be fairly dismissed for that. But again, it's a case by case basis. You do have to do an assessment on whether that is actually a proportionate means of achieving a legitimate aim, or whether there's something less onerous that would achieve the same level of safety.
Of course, and as you highlighted just now, it's so unusual these times, isn't it? No one still working today has ever lived through such a pandemic, and so there's nothing defined in ink on paper exactly about the rules of returning to work and what they mean.
Yeah, it's totally unprecedented. The issues that we're facing, that there is no there's no rule book. Much of employment law is statute, but also much of the interpretation of that statute is governed by case law, and we simply don't have that. There's a few cases trickling through. There was a case not long ago about a gentleman that refused to wear a face mask, and his dismissal was ultimately held to be fair. But each case is based on its own facts. I think what I would say to employers who are trying to sort of grapple with these unprecedented and often unusual and sensitive issues is that one word underpins employment law more than anything, and that's reasonable.
Mm.
That word is used a lot by employment lawyers, and I think if employers are making decisions that affect employees, as long as they are acting within the range of reasonable responses, their decisions are well thought out, documented, and that's very important.
Yes.
Document your rationale. If the way that you're dealing with the situation is reasonable, then it is likely to comply with employment law principles. And employers need to remember that this is new for everybody. There may be a few mistakes that are made. There may be tempers might fray, but I think as long as everybody tries to do the right thing, that they act proportionately and reasonably, they should be onto the right track.
For anyone watching this vidcast who wants to know what to do next, Helena, who do they turn to?
Well, me, the employment team. We have a team of employment specialists, and we're working with our clients through these difficult issues. So, if you'll find me on the Thursfields website. You'll find my contact details, and certainly, I'm enjoying hearing these various different and interesting issues. So, if you've got issues that we've not touched on, I'd be very interested to hear from you, just to talk it through generally.
Helena Morrissey, a Director of Employment and HR Law here at Thursfields. Many thanks for joining us on Thursfields Talk Legal.
No, my pleasure. Thank you.
Anyone wants to know more can contact Helena via 0345 2073 728, or they can email her direct at hmorrissey, that's HMORRISSEY, at thursfields.co.uk. Hopefully, what Helena had to say about Back to the Future and Return to the Workplace is something employers will find useful. We'll be back soon to talk to more legal experts here at Thursfields about other interesting aspects of the legal world. Thursfields Talk Legal. Thanks for listening.